Donna Tope. I'm here on behalf of the plaintiffs, Alec Jerome and Caroline Jerome.
Okay.
They are here by Zoom.
Yes, I do see them.
Good afternoon, Your Honor. Francine Novar appearing on behalf of Eric Cassidy. Gail Rosen from University of Michigan Student Legal Services has filed an appearance on behalf of Paula Cassidy. However, Ms. Rosen is at a conference this week, and so we're proceeding without her presence.
All right.
This courtroom isn't arguing rent, it's arguing ethics. A landlord-tenant dispute suddenly explodes when the judge realizes something dangerous. The landlord's own lawyer may also be a key witness. One role, two hats. And align the court, refuses to let her cross. As the tension rises, Judge Simpson delivers a blunt warning: you can't fight a case. And testify in it too. What follows is a sharp lesson in legal ethics, power, and professional boundaries in a courtroom. Moment that forces a lawyer off the case entirely.
I think the first order of business that we have to take up is before it goes any further, is the motion, I think, filed by Ms. Rosen. So I don't know, counsel, if you were going to, well, who was going to argue that motion? She's not here.
I'm fine arguing the motion, Your Honor.
All right. And counsel, you received a copy of the motion?
By email.
Okay. I did not get a response to the motion, but
I haven't had a chance to respond, but I will today.
okay.
Your Honor, I did also mail the motion on Monday and email it as well.
All right. Well, without here, I've reviewed the motion and I don't need much argument unless somebody wants to argue. And I guess, Ms. Tope, I would ask why wouldn't you be disqualified as counsel? I guess I'm going to start there.
That's fine, Your Honor.
First, because sorry about that.
What would
Why wouldn't you be disqualified as counsel in this case?
Your Honor, their counter complaint is this. Their complaint or their motion to disqualify me is premature. It's not right. There's no certainty that the cases will go to trial. The plaintiff's right to the legal representation of their choice would be irreparably damaged if their attorney, me, were not there to represent them during the preliminary steps before trial. If the case does go to trial, defendants can make the motion then. The defendants claim in their brief that there is a conflict of interest. A conflict of interest does not exist. I, Donna K. Tope, MSJD, has no legal or personal relationship with the defendants in this case. Donna K. Tope, as plaintiff's property managed agent, has no legal or personal duty or legal relationship with the defendants of any kind. The legal brief is an error. Donna K. Tope, MSJD, me, the plaintiff's attorney, is not a party in any of the Cassidy's legal filings. Their counter complaint is against Alec Jerome, Caroline Jerome, Cambridge Family Holdings Property Management Company, and Donna K. Tope, the Jerome's property management agent. The complaint is a documents case. It is a landlord-tenant case for non-payment of rent and termination of the lease, and that the Cassidys violated several terms of the lease between landlord owners Jerome's and the Cassidys.
Okay, Mr. Let me stop you for a moment.
Mm-hmm.
On some of that, you may be correct, but I think the biggest problem that I see, and there are a number of them, but the biggest problem I see is you representing in a case in which you may be a witness.
And my next point is directly on that point, and that is that the case is based on the Cassidys withholding all rent and utility payments beginning with those due September 1st. The defendant's defense is limited to the legal basis for the claim that those repairs were so egregious and made the home so unlivable so as to rise to remedy of withholding rent, all rent beginning December 1st. There are 4 different witnesses. They have filed the case against Alec Jerome, Caroline Jerome, Cambridge Family Holdings, and Donna K. Tope. All 4 of those people could be witnesses for any of the evidence.
But counsel, that doesn't negate the fact that you could be a witness.
I'm not an essential witness. There are 3 other people.
But hold on. I think that you are, if what's contained in here is correct. And that is that you're having these conversations with the other parties.
I'm having these conversations. Could you be a little more specific?
Well, but you're arranging certain things. You're the one talking to them. You're the one dealing
As
with
the
them.
agent is okay.
Right. I get it. I get why you're doing it in that capacity. I don't
Right.
have any issue with
Okay,
that.
I'm just trying to understand
Right.
what.
What I have an issue with are the rules of professional conduct, particularly, and then you representing a party where of rights, because of a conversation that might have ensued, you would be called as the witness. That's a problem.
Okay, the rules of professional conduct, and that is where that is behind what I say that the brief of a conflict of interest does not exist, is because that an attorney in a party to a suit cannot be a witness. I, Donna K. Tope, MSJD, am not a party to any lawsuit that they have filed.
No. But the rule also indicates you can't be the attorney and witness.
The other 3 parties are the best witnesses because they're the landlords.
But counsel, just by being here the number of times that we've been here, what's clear to me is that you're, just by way of example, you've got conversations or have conversations that you've had with the Cassidys directly, with Eric and Paula Cassidy.
Not as an attorney, only as the property management. And they are all related.
Right. But it almost would be better if you had it as the attorney, because that puts you in a different boat. It's precisely what you just said that causes the problem. You are having these conversations, negotiating with them, imploring them, taking their complaint. Hey, hold on.
I'm not negotiating. I'm just managing the property.
Right. But in that management of the property, you're having the conversations with the tenants.
Through their attorneys, always. Now, once these cases began, I do everything through the attorneys as well.
They didn't always have attorneys.
No.
Right? You dealt with them directly.
Neither did the Jeromes.
Miss Tope, I think, and let me just be clear about this. I am loath when an attorney comes before the court to disqualify an attorney ever. I just am. I think attorneys, we're in a profession that is in a lot of ways self-governing. So if there is a conflict. I mean, if you just take the basic structure and you say that if I am an attorney in a case and I could be a witness to something in the case, then you almost have to rely upon the attorney not to enter into representation. Now, having said that, and so typically attorneys won't, right? And so I don't like, because I think attorneys have to make that decision a lot of times on their own, right? And so I don't like to get involved in that. But when it's brought before me that an attorney is going to be a witness in the case, and the other reason I don't like it is because sometimes that can be used from a tactical perspective from one side or the other. And so I went through this in great detail. And quite frankly, trying to find a way that would preserve your ability to represent these individuals. That's really how I approach it when I'm reading it, right? Because what I say to myself is, if an attorney isn't supposed to be in a case, the attorney is going to get out of the case. This other side's filing this to get this other attorney out of the case. So I'm going to operate on the presumption that the attorney should be there. When I finish reading this, and then also knowing and having been here and heard the case, I'll be absolutely honest with you. I don't think you can represent the parties in this case, because you are clearly, in my mind, going to be a witness. Now, I'll stop you, hold it before you say anything.
That's if we go to trial.
But here's what I don't want to end up in. But there can be certain points before trial. In the way I operate my cases, where I set them for a final settlement conference,
Right.
and the thing in certain
Yeah, no,
representation.
I would be acting as their attorney in those pre-trial.
Well, the problem is I may ask for certain representations from the parties, right? I don't want to.
I understand. I get exactly that. There is a problem there because you would be talking with them from, I get that.
And I don't want to be, so the interesting thing about all lawyers are bound by this, that if I see a violation of the ethical rule,
Yeah,
I'm then,
that would be.
hold on, I'm then required to report.
Okay.
Ms. Tope, I do not want to be in a position where I have to report you. I don't do that unless I absolutely have to. And
Thank you very
I don't
much.
want to do that. I wouldn't want to do it to anyone.
So can I just want to suggest that those kinds of, your kinds of reservations, your kinds of concerns would not apply if the Jeromes were representing themselves. And yet they still are going to be witnesses in their counter complaint.
That is absolutely correct.
Okay.
It wouldn't apply to them.
No,
It doesn't.
no, because they're not attorneys under the attorney. Well, I still say that I would like you to wait until we actually come to that Waterloo. But I know that because we may not. I mean, we were hoping that we could get some kind of meeting of the minds at this discussion that occurred without attorneys at the University of Michigan legal department's dispute resolution meeting that took place. And we did not. But if a settlement does occur before I have to come in a legal court proceeding, representing the Jeromes, then I wouldn't have to disqualify myself from advising
Ms.
them.
Toth, I'm gonna have, I've been doing this a minute,
Yeah,
and I'm just gonna tell you, I'm gonna see it on motions. I'm gonna see that
got it,
this issue get raised
got it.
the moment an affidavit's filed.
Yeah,
We're gonna have a problem,
yeah.
right?
I totally am understanding your issue.
And so I don't want, everybody has a right to have their cases heard expeditiously to get through them. And I just don't think that can happen in this case.
Given what's
you
going on.
Representing them. Because and here's the other part. The other part is this is a summary proceeding and maybe one of the thickest or second thickest I've had this year filed. But summary proceedings operate at a different pace. We operate rather quickly. The moment they file a motion, file an affidavit alleging that you said we got a problem.
Yeah,
And then I have to put it on hold, which is not, quite frankly, in your client's interest. I have to put it on hold, waiting for an attorney to come in to just answer the motion, let alone argue.
okay.
Because you would place yourself in a quandary by even trying to answer. You follow me?
No, absolutely.
Okay.
Absolutely. I mean, like an arrow to the heart.
Okay. Well, don't put it that way.
No,
Gonna,
I just got to say,
yeah.
that's what it feels like. But
Okay.
I totally understand.
All right. So I guess my question is, if you, rather than me even ruling on this motion at this time, but if you were, how long would it take for you to find counsel to substitute in?
I will talk with my clients and we will have a speedy discussion because they are on it. And I can get back to you within several days.
Okay. Okay, well, as this side to the Jeromes, based upon the discussion, I realize you guys aren't lawyers, so did you have any questions with anything that the court was saying or anything that was going on there?
Alec, did you want to? I think it's clear. I think I understand what you've said. Thank you, Judge Simpson. And yeah, we can confer and we'll figure it out. There is always a lawyer present. Just because of the nature of the tenants, but we'll find another lawyer that will work and won't cause a conflict. I understand that's super important.
Yes. Okay. So, yes, ma'am.
You did understand what she said, that in every situation involving the tenants, there is a lawyer present on their side because Eric is a lawyer and he has sort of,
right. And if
he's inserted lawyerly things into the discussion.
I get it. But
okay.
But if he were representing, quite frankly, he might have a problem if he were to step in and represent even his wife in this. He could certainly represent himself. I mean, he could do that, but that's not what this is.
Yeah.
Right. And I get there's always a lawyer involved. Sometimes you throw a stone, there's a lawyer involved.
Mr. Cassidy is licensed in the state of Texas, not in the state of Michigan.
State of Texas? My condolences. All right, so, that's it. So I guess, my thought process is to adjourn this out a couple weeks, allow them to substitute an attorney in even before I rule, so that way we're not even trying to do things right now that may cause problems later. But I don't know how you feel about that. We like having you here every couple weeks or so, but
Your Honor, I mean, we really are asking the court to make the decision today. And I think an email that we received last night from Ms. Tope at like 11:30 p.m., coupled with the motion that she filed a few days ago to allow the landlords to repair the property without the tenants present, show how integral she is and what a fact witness she is. She's, in our opinion, the only fact witness. We don't need anybody else. Not to mention the fact that most of our counterclaims are against her individually.
Oh, I know.
Because emotional distress and whatnot that we're going to file is against her.
I know.
Individually. And she has a clear conflict of interest because I presume the Jeromes are going to distance themselves from her and say they haven't authorized the behavior that she's been doing on entering onto their property.
And those are all allegations.
I know. And look, folks. All right. Maybe my problem with being a judge is I'm a lawyer's judge.
Is what?
I'm a lawyer's judge. I love the practice of law and I like watching lawyers practice. And where I don't have to enter into having lawyers do the right thing or whatever, and I don't. I think you had Ms. Tope a certain position that she had. We had that brief interaction we just had now. My understanding is that there will be an attorney substituting in. So what I'm going to do is, this is how I'm going to leave it, because I do understand your point, but you have 7 days to file a substitution of attorney. If not, the court will enter an order granting the disqualification of this. Just do it that way. All right. You're welcome. And I'm not going to proceed on anything else until I have different counsel on this side.
Okay, so they would have to refile my motion that to have the tenants vacate while the landlords do.
No, I mean, I'm not going to require them necessarily to refile. They're going to have to sign something for that motion under the court rules because it has to be their motion.
Okay.
They don't have to absolutely refile it. I'm not.
Excellent.
I mean, there are ways around that notion without causing undue delay.
Yeah.
All right.
Thank you.
So what I will do, and if you would prepare the order that there will be a substitution, right?
Yep.
Or that the court will be granting that. So that order needs to be prepared, submitted to the court. I will adjourn this out 2 weeks. And we will come back. And I'm sorry. Yes, ma'am.
I'm being a little sister. My brother has had his hand raised because he did want to also.
I'm sorry.
That's okay.
I'm sorry. I wasn't looking at that screen.
That's
and I apologize.
Totally cool. Totally cool. Okay.
All right.
Alex,
so you said you were being a little sister when you did that?
Speaking up for my brother.
I wasn't speaking up. I did have my hand raised.
No, it's okay. I have one of those, and you're right. I get him. Big brothers were just quiet until our little sister says, "Got to say something."
Okay, I'm back.
Go ahead, sir.
Your Honor, the only point of question that I had was related to, we actually came today prepared to make an offer for settlement of the situation related to the payment of all of the back rent, penalties and fees, but absolving the Cassidy's of any of the penalty related to the forfeiture or breaking of the lease, which was in the neighborhood of, I believe, $26,000. Does that make a difference in terms of having a discussion or not?
Yeah, no,
That's that the record be stricken on this in terms of any proposed settlement that we have.
yeah, in the court, its head is not, I'm not even dealing with that. The short part of that is you came to try to look to negotiate it. What I'm going to suggest to you is just hold it for a minute in terms of what position you may want to put forward. Let's get other counsel in to do that who can also look at it. And then if that's still your proposal, certainly there'll be time to submit that to the other side.
Yes.
All right,
Okay.
thank you.
We're heard. Alec, you were heard.
All right? Yes. Okay, so what I'm going to do then is I will adjourn this to July 26th. I set it at 9. You will get a time breakdown as to when it'll be set. It's likely gonna, well, no, what time will it?
3 p.m.
Oh, it will be set, thank you. At 3 p.m. All right, on the 26th,
July 26th.
3 p.m.
Thank you.
All right, folks. Thank you.
Thank you, Your Honor.
Thank you. All right. Is that it for that block?
Yes.
That is.
Yes.
You know what? You can tell her I said this. I don't think Rosen had a conference. I just think she didn't want to come back and see me. I hadn't seen her for ages and then saw her, she was in with, is it Fink, I think? Yeah, hadn't seen her for ages. So,
Yeah, Gail's awesome. She actually emailed me last night and said, I wish I could be there tomorrow.
yeah, you got it. All right. You guys take care. Courts and recess. All right. A little late. Okay.
This case proves one thing: the courtroom has rules, and no one is above them. When lines are crossed, judges don't hesitate to step in and shut it down. Truth matters. Ethics matter. And the law always draws the final line. If you want more real courtroom moments where power gets checked and justice speaks loud, like, share, and subscribe. More cases, more consequences, more reality, right here.